financial and commercial litigation, international arbitration and UK tax litigation, some of the most pressing issues for large corporations. Here to speak about the changes to international dispute resolution is Greg Joseph and Tom Beazley QC from Joseph Hage Aaronson, a leading law firm in this area. Well, Tom, your firm is involved in some of the most significant and challenging litigations in the world. What are some of the high-profile cases you've worked on, and what to you constitutes a good result?
The most important and significant cases for us at the moment are where we have commercial clients in an adverse position with states, whether they be in the tax area or in areas like annulment of sanctions, or investment treaty claims, or other claims for investors under investor agreements. And it's in those areas which verge between state immunity, the ways in which you can challenge states now as commercial entities, which you didn't used to be. Those are the most significant cases for us in the London office. Well,
Greg, what areas does your firm focus on, and do these represent a trend in commercial and financial cases at the moment?
We will deal with pretty much anything that's complicated. Now, what we find ourselves doing, because New York is a financial center like London is, are a lot of financial cases. So over the years, those have changed. For a long time after 2008, they resulted from the demise of the credit system, so credit default swap litigation was very intensive. Recently, we've seen an enormous number of cases that are focused on the use of insurance products as investments and litigations that are arising out of that, which include antitrust and a variety of other kinds of financial and commercial kinds of things. I think what we finally are seeing is the end of the 2008 cases, the asset-backed securities cases, and we're going on to the next generation.
Well, Tom, your firm has offices in New York and London, so what do these different litigations, what advantages do they represent for your clients?
Well, I think they give us the opportunity that we can both tap into each other's knowledge base, experience and expertise. And there are significant overlaps between US cases and English cases, but we also do cases all around the world, and so where we can, we would try to work together, whether it's in arbitration or litigation, wherever it might be.
An acquisition that went poorly for a major US client, they recently needed advice in the UK for a completely separate litigation and asked about the availability of using UK resources. We've also used Tom or others for UK affidavits or expert declarations in US litigation, because cases in New York do arise frequently under English law, just as cases in England occasionally pick up issues of New York law.
You also deal with a lot of antitrust intellectual property cases. What should people be aware of in these situations?
It's an interesting overlap between the two, because in the United States, intellectual property gives you a monopoly, but the plaintiff would call it an abuse of that monopoly gives rise to antitrust issues. So we're seeing a number of cases arising in that area, and it's a convergence of two rather diametrically opposed views of the law. One is a guaranteed government-provided monopoly, and the other is a government-forbidden monopoly. And it's a convergence. It's quite interesting.
Well, Tom, how have investor-state claims changed over the last few years?
I think there's a considerable growth over the last few years in investor-state claims. They're not just restricted to bilateral treaty claims, they can come under multilateral treaty claims. And I think it's the growth of the number of cases combined with a shortage of arbitrators that presents a real problem in a really successful development of the whole area of bilateral investment treaties.
Well, Greg, finally, what's your strategy for future growth?
How large to grow? That really is the fundamental question, because maintaining a relatively, well, we like to consider it the right size, but a smaller size permits great exclusivity in case selection. And there's always a tension between growth and focus. I'm of the view in New York that I'm rather content with the size we've got. My colleagues in London are doing a wonderful job of growing the firm. And I think between the two we'll find a happy medium.
Greg, Tom, thank you.
Thank you.